This is how the American justice system really works, not the TV version, not the courtroom drama edits, but the real thing. Fast-paced, procedural, and absolutely unforgiving if you don't understand what's happening. Keep your eyes on the details here, because every yes sir matters.
On Jaylen Ross?
Yes, Your Honor. Yes.
Court is calling 2025 CR 004086 off the record for a moment. And Norma, Mr. Hayek is not here. Mac is here. Could you let Mac know which client that is? All right, we're back on the record. Could I have parties announced for the state? Defense?
I need the fetish for the defense.
I'm sorry, what? Okay. All right, and the court is also calling 2025 CR 00003533. And you're Mr. Ross? Okay. Counsel, each of the cause numbers, did you receive all discovery and review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Ross, in each cause number, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, I did.
And each cause number, did you review the true bill of indictment with your attorney? Did you?
This might sound routine, but this is a massive checkpoint. When a judge confirms your discovery compliance, it means the defense can't later claim they were blindsided. In plain English, whatever evidence exists, texts, calls, reports, it's now officially on the table.
Understand it. Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented in the cause number ending in 33? And are you proceeding on the indictment as presented in the cause number ending in 86? Mr. Ross, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
And cause number 2025 CR 00003533, you're charged with assault, family, household, impeding breath or circulation. And in cause number 2025 CR 004086, you're charged with violation of bond or protective order 2 times or more within 12 months as a 3rd-degree felony. Range of punishment in each of those cause numbers is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw.
Let's pause here. 2 to 10 years in prison, this isn't a slap on the wrist case. Even though we're hearing calm courtroom voices, the legal exposure is very real. Deferred adjudication may sound lenient, but one wrong move later and the full sentence comes crashing back.
Your plea, did you understand?
Yes, I did.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering into these plea bargain agreements, you were giving up those rights. Did you intend to give up those rights and enter into a plea in each cause number?
Yes, I did.
In each cause number, did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
This is the moment most defendants don't fully grasp. By accepting a plea, you're giving up your right to make the state prove its case. No jury, no cross-examination, no dramatic witness moments. The courtroom gets quieter because the fight is ending.
Yes.
Counsel, in each cause number, did your... I'm sorry, I'm just seeing who's coming in. All right, in each cause number, has your client been able to provide you with any defenses?
Yes, he has, Judge.
In each cause number, do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe he does.
In each cause number, do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I believe so, as to both cases.
Mr. Ross, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the pleas?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it? In each cause number, punishment is to be assessed at 4 years in the prison. There is a $1,500 fine. State is silent on your application. The cases will run concurrently. There's to be no contact with the complainant. And in the cause number ending in 33, there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the plea? Defense, is that the plea?
Yes, that's our
State.
understanding.
Is that the plea?
It is, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did.
Counsel, are there any such motions?
No, Judge.
Then in cause number 2025 CR00003533, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2025 CR004086, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Your Honor, with regard to both cases, state offers in the evidence.
A no contest plea isn't innocence, it's strategy. He's not admitting guilt, but he's also not fighting the charges. Why does that matter? Because it limits admissions that could come back to haunt him later, especially in related civil or family court issues.
Any
No,
objections?
no objection, Judge.
In each cause number, did you review the waiver and consent to stipulation of testimony with your attorneys? Did you understand it? Did you sign it in all the appropriate places?
Yeah.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, so in the cause number, and maybe I don't see it, in cause number 86, I don't see the other dates. I don't see the December 6th, December 11th.
What those dates are referring to, which I guess we could figure out how to put in situations where those were days that the defendant called the victim from jail. So those would be reported to jail.
All right, so,
And we've been provided with those, Judge.
I'm sorry?
We've been provided those.
Well, are you stipulating that, because he pled no contest, is there a stipulation that he made phone calls to the complainant from the jail on December 6, 2024 and December 11, 2024? And December 15, 2024, December 20th, 2024, and January 25th, 2025?
The last date was not, that was the part of the report attachments where he had allegedly had contact with her through social media after the relationship.
All right.
So as far as that, Judge, we're pleading no contest. My client has no prior offenses.
No. I'm
No,
trying
but
to see if
I'm
there's,
trying to get there. I'm trying to get there. As to our application we are applying for deferred adjudication. And so because of that, I would not want him to make any stipulation. So that's why I asked him to plead no contest. Because if the court should grant him deferred, then
well, here's the thing. I don't have that in the stipulations to prove the 2025 CR004086. Now, if somebody wants to amend this and attach jail calls, they can attach it, but I don't have enough proof in here for these other dates. The only date that I have in the stipulated evidence is I have a date from January 5th for violation of protective order, but the other dates I don't have in here. Sure. So if y'all want to step back, you can, but in cause number 2025 CR003533, the court is finding that there's sufficient evidence to find you guilty. The court will defer finding of guilt. It takes about 8 weeks to 12 weeks for a PSI. If you would like to have him come back without a PSI, but just have time to call witnesses, you're more than welcome to do so.
So I've conferred with my client, and I've also contacted family members, and my client wishes to waive PSI. and just have the court, and that was why we took a little bit of a recess, Judge, before we got on the bench, is just to confirm the criminal history. And so at this time, we're asking the court to waive PSI, and we proceed with sentencing today.
All right, and counsel, where are you saying this?
Can you repeat the dates, Judge?
The dates
That they're in question?
the dates that are in question for the court are, I have a December 3rd, I have a December 5th date. So December 5th and count 1, that's paragraph 1. So I'm looking for the December 6th date. I don't see the December 6th date in here. And then there's a December 11th date. I don't see the December 11th date in here. Okay, so where's the